everyone, this is Attorney Anish Rashidska speaking to you from Los Angeles, California, where we discuss immigration issues. My law firm specializes in U.S. immigration law, and we also deal with some Canadian matters. Today I wanted to talk to you about H-1Bs, and I know we're still a few months away from the H-1B filing window, but I'm not talking about new filings. What I am talking about are H-1B transfers, because I've been getting a lot of questions from various people throughout the country about H-1B transfers, and the questions are all the same and the answers are all the same. But I want to see if there's a way that we can streamline the process and give everyone the answers that they want without having to call around to multiple lawyers, possibly because the lawyer for the employer is not responding to them quickly enough. And it's always the same type of scenario. I'm going to be looking at one that was sent to me last week, and I'm going to paraphrase it. But essentially, there's this gentleman who is out in the middle of the country, and he received an H-1B back in 2017, and it's valid until 2020. However, he lost that job, and during the 60-day grace period, he transferred to another employer who filed an H-1B extension petition for him. It was an H-1B transfer. That was approved, but it was only approved up until sometime later this year. And so his concern is that he needs to have it extended beyond that. Well, fortunately, his current employer, who we'll call Employer B, because Employer A was the one through whom he got the initial H-1B and from whom he lost his job. But Employer B filed another extension for him to extend his H-1B status beyond that 2019 deadline. Now we come to the common thread. He has received a job offer from Employer C, but Employer B's extension petition, second extension petition for him, has not yet been approved. The question is, can he switch to Employer C? To answer these questions, or this particular question, and then the natural follow-up questions that come from that, one first has to understand the difference between the H-1B petition and the H-1B change of status request. Now, many times people call it an H-1B transfer, but what that essentially is an H-1B change, and possibly with an extension. I say possibly with an extension because if the transfer petition is going to be seeking time beyond the expiration of the already approved H-1B status, then it's also going to be an extension. The term transfer is misleading because although it's commonly used, it doesn't really fit into the Immigration and Nationality Act terms that lawyers use and that U.S. Citizenship and Immigration Services use. Because essentially every transfer is a change of status, possibly with an extension. Now you'll say, well, I'm not changing from H-1B to some other status, but because H-1B is an employer-specific category, you're essentially changing your status from H-1B with Employer B to H-1B with Employer C. And in that sense, it's a change of status. So when we're looking at the petition and the change of status request, it's important to understand the difference. An approved H-1B petition merely means that USCIS has found that the petition itself is approvable, meaning that the employer has properly filed the petition, the prospective employee has the required degree, and the position is for a specialty occupation that requires that type of degree. Whether that petition is going to be approved for a change of status depends on whether the beneficiary, the prospective employee, is in status or will be in status by the effective date of that approved petition. If not, then the petition should be approved only for consular processing. What is consular processing? It's also known as visa stamping. Basically, for the prospective employee to leave the country, apply for an H-1B visa at a U.S. consular post abroad. It's either going to be a U.S. embassy or a U.S. consulate, and then to return to the U.S. on that visa. To be clear, the visa cannot be obtained within the U.S. Only status can be had in the U.S. So to get a visa to enter the U.S., one has to leave. To obtain status, whether it's a change or an extension, one must be in status by the effective date of the sought status. So when an H-1B petition is being approved, the approval notice of the petition will say whether it's for a change of status or it's for consular processing abroad. Now let's come back to the initial question, which is a very simple question. Can I do it? Can I go from employer B to employer C, start working for employer C upon the filing of an H-1B transfer petition by employer C without yet having employer B's extension or second extension approved? The answer is, in short, yes. But there are many caveats that one has to be aware of. First, the transfer to employer C, while one can start working immediately upon the filing of that petition, that petition could be approved. Whether it will be ultimately approved for a change of status, meaning the person does not have to leave and apply for another H-1B visa abroad, will depend on whether employer B's petition for the extension is approved. Now, if an employee just leaves employer B and starts working for employer C, I can imagine, and many of us can imagine, that employer B will no longer want to pursue that petition for the employee and may withdraw the petition, in which case the bridge could collapse. And when I say the bridge could collapse, it means that the time period, if there's any time between when employer B's approved petition would expire and when employer C's petition would be filed, that gap presumably was supposed to be filled in by the pending second extension petition by employer B. But if that extension petition is withdrawn, then the bridge has a gap in it. And one can't cross a bridge if it has a gap in it. So employer C's petition in that scenario would be approved, but not for a change of status. It would be approved for consular processing. Another scenario would be if employer B's approved extension petition were still valid, and even though it filed for an extension, the approved petition is still valid, and employer C filed an extension petition while the first extension petition by employer B is still valid. Employer B withdraws its petition because it's upset or because it no longer wants to pursue a petition for an employee who has left. In that scenario, the change of status could be approved along with the petition. Why? Because there's no gap. Why is there no gap? Because employer C's extension or change of status petition was filed before the expiration of employer B's approved petition, even if employer B's second extension petition was still pending at that time that employer C's change petition was filed. If you don't like the analogy of a bridge, I find it easy to understand, but many people don't grasp it. The way you can view it is in another sense. Just think about a monkey swinging through vines. When an employee leaves employer B before employer B's petition extension or second extension petition has been approved and grabs a hold of employer C's petition, what ends up happening is you may end up letting go of both vines, because once employer B withdraws that petition, that extension petition, employer C's petition, even if it's approved, it won't be approved for a change of status. And so the monkey ends up falling because both vines collapse, because neither of them can sustain the monkey's status. I'm not, of course, saying that anyone here is swinging through vines, but it can sometimes feel that way when you're trying to traverse the H-1B landscape. So, just to be clear, the changing of employers, moving from employer A to employer B and to employer C, that has no impact on whether a petition, H-1B petition, can be approved. What it has an impact on is whether that H-1B petition can be approved for change of status or for consular processing. And that's the important thing to point out. And if you want it to be for a change of status or an extension of status or an H-1B transfer without having to leave the country, then it's important to know that there can be no gaps in the bridge, and to be on the safe side, you should not let go of employer B's vine until you know that employer C's vine is going to be secure. Now I'm mixing the analogies, but what that means is if one is in a scenario where he or she doesn't know whether to leave employer B, one possible scenario is to have is to work for both employers. Now, you don't necessarily need to tell both employers you're working for both of them, but it's not exactly a transfer. It would be a concurrent employment if one continues to work for employer B while employer C's a transfer petition or change/extension petition is filed and pending, and only leaving the employment with employer B once employer C's petition is approved. That way, there's no risk of having a gap by the between when employer B's petition falls through by the employee leaving employer B and when employer C's petition being approved. That's the concern here. Now you can say, well, why would it have to be concurrent? Oftentimes I've seen that employees have a difficulty in not going to work for employer C immediately upon employer C's filing a transfer petition. Employer C doesn't want to wait until the petition is approved and wants the employee to start working for employer C immediately. And if at that time employer B's extension petition is still pending and the prior approved extension or change petition by employer B has already expired, if one leaves to go to employer C and employer B then it withdraws the extension/change petition, then there's going to be a gap between when employer B's approved petition expired and when employer C's transfer petition was filed. And with such a gap, one can't change status. One will have to leave, and of course that runs the risk of being delayed by administrative processing at the U.S. consulate post abroad and loss of income. So I hope that clarifies things. I want people to know that if they have any questions, they can always reach out by calling my law firm either at 323-592-9980. Again, that's 323-592-9980. Or they can email me at consult@lawfirmav.com. Again, that's consult@lawfirmav.com. I'm happy to answer any questions, but I ask that people make an appointment. If you want to have an initial in-person consultation, it's free of charge. But if you want to have a telephone consultation or a Skype consultation, we do charge $200. If the questions are largely going to be about what we just discussed, and I ask that people listen to this recording again before contacting my firm to ask these same questions, because the purpose of this recording, of this podcast, essentially is to try to answer questions so that potential clients when they come to see me or talk to me, they're more informed and we can have a more productive conversation rather than doing what I call Immigration 101. If you're in the Bay Area of California, then you can reach our office at area code 510-585-3990. Then it's 510-585-3990. LA area, and probably anywhere else in the world, you can reach us at area code 323-592-9980. Again, 323-592-9980. Email me at consult@lawfirmav.com. Check out our website at www.lawfirmav.com. I have various blog posts, and you can hear all my recordings at that website too. Until next time, I hope that everyone stays safe during this shutdown and during this current administration's scrutiny of various immigration petitions and changes in policy, including the NTA policy, which you can read about on our developments page of our website. And always try to get the best legal advice and assistance you can regarding immigration matters.